HOA Karen had leveled so many ridiculous complaints by now that they'd been filed into a small mountain at the county clerk's office. So when she decided to sue me for refusing her access to my ranch, I should have expected fireworks. What she didn't expect was that I was a retired attorney who still remembered how to read the room and the rules. It started with a polite knock on my gate. Karen stood there, a thick envelope in hand and a grin that said she'd already imagined the headlines. "You're blocking community access," she declared. "I'm filing suit. You can't deny neighbors reasonable use of shared areas." "Shared areas?" I repeated, smiling the way a man smiles before he lets the law take over. "Show me the easement." She produced HOA minutes, a hastily scrawled neighborhood map, and a letter stamped with the HOA logo. It looked impressive if you didn't know how to spot a forged signature from 30 paces. I politely told her I'd look it over, and I did, over coffee, with my old briefcase out on the kitchen table. 2 days later, Karen had a summons served. The envelope was thick. She'd hired a lawyer, one who billed by the panic attack. Her complaint accused me of unreasonable interference, denial of community easement, and the sentimental kicker, emotional distress to HOA members deprived of pastoral view access. I called my old contacts, dusted off a stack of legal robes I like to keep in the closet for show, and began the slow, satisfying work of discovery. What discovery found? The easement Karen cited was actually a misread map from 1973, a utility corridor that had been vacated in 1981. Her HOA minutes included signatures that didn't match the official signatory records. Multiple neighbors, the ones she'd claimed represented, signed affidavits stating they never authorized any claim on my land. Security footage showed Karen crossing my property line repeatedly over the previous year, planting markers and taking measurements with an air of entitlement. At the preliminary hearing, her counsel launched into a dramatic monologue about community rights while sliding a glossy binder toward the judge. I smiled, stood, and gave a short, precise history. Title chain, recorded deed, county plat, and the quiet, heavy point that private property is private property. I then handed the court the discovery packet like a chef presenting the entree. The judge, an old friend who loved a clean brief and hated flimsy theatrics, raised an eyebrow and leaned forward. "Mr. Hale," he said, "you've demonstrated prima facie ownership and the likely invalidity of plaintiff's easement claim. We'll allow a motion to dismiss and consider sanctions." Karen's face, already accustomed to being read, went an alarming shade of crimson. We didn't just move to dismiss. We counterfiled. Trespass, harassment, abuse of process. We asked for costs, attorney's fees, and a formal hearing on the HOA's governance. During discovery depositions, her HOA minutes unraveled like an old fishing net. Vague votes, phantom quorum numbers, and one particularly damning email showing Karen instructing volunteers to plant stakes to strengthen our position. Planting stakes on someone else's land. The sanctions hearing was poetic. I let the evidence speak, then I let the law do its work. The judge, unimpressed with manufactured governance and bogus claims, awarded the motion to dismiss and levied sanctions against Karen and the HOA's leadership. She was ordered to pay my legal fees, remove all markers from my property, and issue a public apology in the HOA newsletter. A retraction printed front page, in bold. But the best part was the injunction. The court issued a permanent order. No HOA activity on my property. No attempts to claim easements without recorded, county-approved documentation, and a 30-foot buffer where HOA members were not to cross without written permission from me. Karen was required to attend a civility class for community officers and to undergo supervised mediation before approaching any neighbor about property-related issues. On the day the ruling was read, Karen tried for theatrics, the same raised voice, righteous routine. But the judge cut her off with one of those looks that can make a grown lawyer feel like a schoolchild. She left the courtroom under a smoking cloud of humiliation, papers clutched like wilted flowers. Neighbors who had been quietly annoyed by Karen's constant interference came by to shake my hand. A few offered apologies for being coerced into supporting her campaigns. I accepted their words with the same measured kindness I'd used in court. Justice, after all, doesn't have to be cruel to be final. That night, as the sun sank behind the pasture, I walked the newly quiet fence line, thinking about the strange etiquette of property. Respect it, protect it, and prepare for fools who mistake bluster for right. Karen's lawsuit had been another attempt to weaponize noise against ownership. It had failed spectacularly under the weight of documents, depositions, and the stubborn fact that deeds matter. In the weeks that followed, the HOA board restructured, instituting real oversight. Karen resigned from any official capacity, a humiliation she announced with a terse, drafted email that no one read kindly. She still drove by sometimes, staring at the gate like a man peering into a room where his invitation had been revoked. She never again attempted a legal claim on my property. As for me, I returned the legal robes to the closet, poured a glass of iced tea, sat on the porch and let the evening cowbells ring. The law had spoken, not loudly or vindicatively, but precisely and cleanly. That's how justice on a ranch usually looks. A slow turning of facts, a patient application of rules, and the quiet restoration of peace. And if Karen ever forgot why she couldn't stroll onto the pasture, I kept a copy of the judgment in a little frame by the gate, right under a small sign that read, "Respect the fence, respect the deed." It was enough. She saw it every time she drove past. And every time, she lowered her eyes and kept going.